In this second video for this week, I will cover international custom, or as it is more widely referred to, customary international law. If you haven't had a look yet at the first video where I generally described the foundational principles of state consent and pacta sunt servanda, have a look at this before you look at the second video. I also want to mention that I will cover the first source under Article 38 of the ICJ statute, which are treaties, only in the videos for next week, as we will then also dig more deeply into the topic of treaty interpretation and reservations, for example. So what then is customary international law? Well, Article 38 of the ICJ statute refers somewhat enigmatically to evidence of a general practice accepted as law. And I would argue that is not particularly helpful for understanding customary international law because it doesn't tell us anything about the specificity that this kind of source entails. First, we need to understand that when we talk about international custom, we're not talking here about particular societal rules that apply across countries in various cultural settings. No, we are talking here about the very specific international customs that states have adopted in their conduct vis-à-vis one another. So these are state practices, and this is indeed the first elementary feature that we need to understand on a sort of conceptual level. One thing that we need to prove, or what we need to show when we are speaking about customary international rules, is that there is a widespread state practice that underlines this rule. Now, the second aspect is that the creation of customary international law is not exactly straightforward. Next week, we will talk about treaties, and we'll see here that the negotiation and adoption of treaties, well, they are specific rules that are applicable and that we need to understand, but on some general level, it is relatively straightforward. Treaties negotiate explicitly wording, and then they pass it, and eventually they ratify it. Well, when it comes to custom, we actually have the opposite. There are not many general rules, and in principle also, it is an implicit process by which states over time, gradually, rather than in one specific moment, adopt practices that are then considered legal obligations. Purely from a conceptual standpoint, there are actually two elements to the notion of customary international law. And that is, on the one hand, state practice, and on the other hand, opinio juris. So one more objective element and one more subjective one that, coming together, establish or create norms that are then qualified as customary international law. The first element is arguably easier to understand. When we talk about state practice, then we talk about what states actually do. So how do they behave? And more specifically, we ask whether their behavior, their conduct has reached a level of uniformity that would actually reach a certain threshold that would then qualify as a general behavior that would create an international rule. You can already see here why customary international law is controversial. Whether there is sufficient uniformity in state practice, whether states sufficiently behave in a similar way, is a little bit in the eye of the beholder, and it is actually then often up to courts to decide whether this threshold has been reached. It is for this reason, so not just because it is actually also a prerequisite, that it is important to look at the second subjective element, which is called opinio juris. Now, the idea here is that there might be a certain level of generality in state practice, but not all of these kinds of practices actually reflect a legal norm. To give you one example, when one head of state visits another state, that hosting state will habitually roll out the red carpet to welcome this representative in a proper manner, to show deference and respect. But states do so out of what is called comity in international relations. They do so because they think this will help the relations between the states. They do so for political, arguably perhaps even moral reasons, but they do not consider themselves to be legally bound by this norm. So there are different types of norms, and only these legal norms that include an opinio juris, which is the Latin phrase, so to say, for a legal opinion or a view that this is actually law, only then does state practice actually amount to customary international law. So only taken together, only if we have state practice that is deemed by states to be actually a legal obligation, only if they come together do we actually have a norm of customary international law. Now, this is all nice and fine, but how do we establish whether these conditions are met? Now, in the case of treaties, as we will see next week, it is relatively straightforward. We check whether a treaty has been signed, whether the language used there is actually a legal language, and whether it has been ratified, and then we have a legal obligation. Well, when it comes to customary international law, things are not as straightforward. We actually have to consider a variety of sources and then check whether, in fact, these conditions, the subjective and objective element, has been met. Next to me, you will see a number of elements that can actually be indicative of these elements. So material acts, legislative acts, judicial decisions, statements, treaties also, but also declarations, all of these can be reflective of a customary international rule. And to make things more complicated, they can be reflective of either of the two elements. So they can be reflective on the one hand of state practice. So if you assemble enough evidence of these elements, that would actually mean that we have enough state practice, but they are also reflective of opinio juris, in particular when it comes to statements, in particular when it comes to declarations that tell us also a little bit about how governments, how states perceive their conduct and whether a legal obligation underlies what they're doing. So then how many states does it take to create customary international law? Again, not straightforward, but a question that at least has received an answer by the International Court of Justice. In fact, on several occasions, the International Court of Justice, of course, the most authoritative court when it comes to general principles of international law, the UN court. And the ICJ, in its Nicaragua decision, for example, has stated, as you can see here, that a rule to be established as customary doesn't need to show, or state corresponding practice doesn't need to prove absolute rigorous conformity, but that it is sufficient that the conduct of state in general is consistent with such rules, and that instances of state conduct inconsistent with this rule are treated as breaches of this rule and not as an indication of a new rule. Because of course, any state practice that is in contravention could, at least in principle, be emerging practice that then gives rise to another rule, but it should not be treated as such, notably by other states that see this violation and identify it as such. This being said, there are also different scopes for customary international rules. Now, most customary international law will in fact be global in scope and will apply to all states. Think, for example, of the law of the sea, the fact that the high seas are open. Such a customary rule has been applicable for centuries, if not millennia, and has been respected and is valid in each part of the world. Now, we also have more regional customs. The one paradigmatic example here is always the diplomatic asylum that Latin American states in particular are according to people who are fleeing from persecution in their embassies. Now, on some rare occasion, customary rules can also emerge instantly. This is rare and exceptional because, as we saw with the law of sea example, usually it takes much longer time. But in certain areas, think most notably of international space law, where until the 1950s and 1960s there was no space exploration to begin with. Rules are needed in a very short amount of time. Few states are involved, but these states hold a genuinely legal opinion that the state practice or the behavior they are showing is in fact indicative and reflective of a legal norm. Finally, and this brings me to the reading question for this clip, we have the notion of the persistent objector and of historic rights. Think back for a moment to the notion of state consent and the fact that for an international legal obligation to exist, a state must have agreed to it. Now, you can see here that when it comes to international customary rules, of course, them developing over time and in an implicit way, there might be some tension with the idea that the state has actually consented to it, in particular if this custom arises, but the state somehow never actually engaged in a similar conduct. This is where the notion of the persistent objector comes in. When a state sees that a customary international rule is arising, and when the state very explicitly rejects this idea, so becomes a persistent objector from the very beginning, then the state gains a so-called historic right, in the sense that this right means that they are not bound by this new international legal obligation that emerges. Such historic rights, of course, complicate matters further, but we can see here that the consent-based nature of international law requires such persistent objectors to be accepted, because otherwise, again, the principle of state consent would not be respected, and this is, as we saw, the pillar of international law. This completes the second video. I will now move on to talk about general principles of international law and other kinds of sources, including subsidiary sources, that are relevant for our understanding.